State of Michigan versus Isaiah Hollins, 26-00999. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people. Assistant Public Defender Joseph Hardy. Mr. Hollins attempted leaving messages last week. Yesterday, I checked. He does not appear to be in custody either. Did not see him follow that.
Have a witness here.
Yes, Your Honor. Witness Irma Gomez is currently present and in the jury room. So at this time, given the defendant's failure to appear, we ask that the bench warrant be issued and Irma Gomez, I think this is yeah, I asked that the bench warrant be issued.
A bench warrant will be issued, and the witness will not be required to appear for any further final pre-trial. Additional matters for the record.
Not from the people, Your Honor.
This is State of Michigan versus Amadou Mbao, 26-01040. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor. Jack Rucker appearing on behalf of Mr. Mbao. I've not seen Mr. Mbao in the courtroom today. Is he?
No, he close to.
Is he on Zoom?
No, they said he was running late earlier, so he's supposed
Is he
to.
the one that holds
Yes.
for the bus?
Yeah.
Oh, okay.
If the court would pass the matter, we can call it when he arrives.
Okay.
Thank you, Your Honor.
State of Michigan versus Leon Middleton, 26-00997. Yes.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Assistant Public Defender Justin Straub on behalf of Mr. Leon Middleton, who is sitting to my right.
Okay, Mr. Middleton was scheduled today for final pre-trial. Do we have a witness here?
At this time, Your Honor, we do not have a witness here. We have reached out to Amber Watts. We've sent subpoenas to her last known address. We made multiple attempts to contact her via telephone. At this time, the people cannot proceed without the complaining witness, so we move to dismiss it at this time.
Dismissed without prejudice. That means the people have the right to reissue that against you. Do you understand that, sir? You have any questions? Okay, we'll get you dismissal in just a moment. Michigan versus Avani Stitt, 25-03584. Appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Good morning, man. Please, Honorable Court, Kareem Johnson, P number 71988, Phil Daphne Stitt, stands to my immediate right.
Okay, I'm assuming the victim's not here.
The victim's not here. I've had multiple contact with her. They are sisters. They
They're
are
co-victims in another case that I have now.
They are co-victims in that case for in the interest of justice.
Which, by the way, would be evidence of a bond violation.
Yeah, so in the interest of justice, we need to dismiss this case.
And I'm not aware of any subsequent cases in terms of any alleged bond violations. We humbly ask this court to allow for the dismissal of the.
We already have a bond violation pending that was set for a hearing today. So for Ms. Stitt to come here when I am well aware that Ms. Straub is representing a defendant whereby the allegations are that this defendant allegedly feloniously assaulted Ms. Stitt and the person that's supposed to be here today. I'm going to reset the bond violations for the day they're supposed to be here for that case. They'll both be here then.
I guess because of the potential Fifth Amendment implications of our testimony, can I be here as well? Your Honor?
You should be, because I'm studying this bond violation. I'm not dismissing the case until I
Okay.
address the bond
Yes, Your Honor.
violation that's been pending that was set for hearing today. Because what Ms. Stitt's gonna recognize is that when the court gives you an order, you don't violate it.
Yes, ma'am.
Yes, we will reset this matter.
What does that matter? Is that for July 7th. At what time? At 8. At 8 in person at the court. Any additional matters for the record?
Nothing from the people, Your Honor.
What was that date again? Yeah.
July 7th at 8. Oh, wait, yeah, at 8. Okay. Where's it? Yeah. Oh, okay, got it. Or do you want it to? No, I didn't. I thought the felony was both of them. I didn't think the felony was both. I didn't think the misdemeanor was both. Okay, and the peer review is that for the citizen. Got it. Okay.
Thank you very much.
Thank
Your Honor.
Yes, please.
Okay.
You can go have his tether removed. Christie is downstairs.
Yes.
This is the state of Michigan versus Aswana Thurman 26-00592. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Anjana Thurman, who is standing to my right.
Okay, today is the date scheduled for a crime violation and a assault and battery final pretrial. Do we have necessary witness here for the underlying charge?
Your Honor, we do not. We have subpoenaed the complaining witness. We've made multiple attempts to reach out to the complaining witness. They have not had good contact with our office. So at this time, we would move to dismiss.
So the alleged victim, her mom,
Mhm.
It's her sister.
her sister.
Yes.
And what is it? Okay, got it. The bond violation involves the mom. That's what the issue is. Someone was subpoenaed for the bond violation.
Ms. Thurman and Officer. Yes.
But no one's here.
And Officer Moreau, but no one's here.
Are you continuing your mental health treatment?
Yes, ma'am.
Motion to dismiss is granted. As well as the bond violation at this time. The people do have the right to reissue this against you. Do you understand that? The people have the right to reissue this charge against you. Do you understand that?
Yes, Your Honor.
Okay. Do you have any questions?
Is the bond dropped as well?
The violation is dropped as well.
The bond.
The bond is over because
Okay.
the case is dismissed.
Okay, thank you.
We'll get you a copy of dismissal in just a moment. State of Michigan versus Christopher Askew, 26-00803. Yes.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Mr. Askew. Attempted to leave a message last week, as well as yesterday. Just tried reaching out to Mr. Askew this morning as well. So far, no response.
Sure, bench warrant about forfeiture. Bates is in custody, or they gonna put him, he's downstairs,
Yes.
or she's downstairs. Okay. State of Michigan versus Louis Moshi, 26-01295. Yes, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Or Your Honor, Michael Puckett, student attorney practicing under MCR 8.120, under supervision of Justin Strong.
Motion to practice is granted. You are here today, Mr. Moshi, for domestic violence.
Yes, I have.
Okay, this is a pretrial. Was there an offer at this time?
There is been no offer extended at this time, Your Honor. We haven't. So we would ask that this matter be set for final pretrial, give us an opportunity to work with the defense counsel to see if we can resolve this matter.
Your Honor, that we would also ask for this matter to be set for public pretrial.
Final pretrial July 14th at 8 a.m. Jury trial August 18th at 8 a.m. Final pretrial July 14th, 8 a.m. in person at the court. Jury trial is going to be scheduled for August 18th, 8 a.m. also in person at the court. We'll get you a notice to appear. Do you have any questions at this time, sir?
No, I don't.
Any additional questions?
Nothing from the people, Your Honor.
Nothing further.
Continue. State of Michigan versus Donald Ward, 24-03101. That's for the record.
Your Honor, may it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. Michael Puckett, student attorney, requesting permission to practice under MCR 8.120 under supervision of.
Ward present.
Your Honor, we are not sure if he is here yet.
I'm sure I've been sworn upon. Christie. You're fine here?
Yeah.
For the record again, in the matter of the state of Michigan versus Amadou Mbao. Here,
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. Jack Rucker appearing again on behalf of Mr. Amadou Mbao, who is standing to my right.
okay, this matter was scheduled for a second pre-trial. No, a final
Final
pre-trial.
verdict.
This was a final pre-trial scheduled, the matter scheduled for jury trial on the 14th. We had a witness here.
No, Your Honor, we have attempted to reach out to a Ashley Park. We've sent her a subpoena. We have attempted to contact her via phone and send a detective out to see if we can make contact with her. At this time, we don't have the contact. We cannot move forward, so the people are moving to dismiss the case.
A motion is granted without prejudice. That means that the people can reissue this charge against you. Do you understand that?
I'm sorry, Your Honor, he's a little hard of hearing if the court wouldn't.
The motion by the prosecution for this case to be dismissed is going to be granted. However, they do have the right to reissue this charge against you. Do you understand that?
Okay, he's having a hard time, Your Honor. I will explain it to him in the hallway at a closer volume.
Well, you
but-
can explain to him on the record.
Very good. So, Mr. Mbao, what the judge is saying is that the case against you is being dismissed. So we will not have the trial on the 14th. However, it is being dismissed without prejudice, which means that they can bring the case back if they were to get in touch with it. You understand that? Court satisfied?
Do you have any questions?
Any questions? No.
Okay, we'll get you dismissal in just a moment.
Thank you very much, Your Honor.
No problem. Is Matthew Macon here?
No, Your Honor, I have not seen him this morning. nor have I heard
PSI. Christine, Matthew Christine. Judge, for today's schedules have been tempting, but she's technically disposed for the disposition for the currency. Wait, what happened?
her trial.
So the.
But I'll reach it back out to her, talk to her before that date.
Schedule her before this, but she's
Waiting for
I'll be
forensic?
out.
Yeah.
Yeah. I think he felt to appear, so. Whenever they pick him up.
Got it. Who represents Tammy Bates?
Your Honor.
She's still waiting for forensic. We're gonna reset the bond violation until we get it, after we get a report. She's not, she will be remanded until then.
July 14th. That's for review.
July 14th, yeah.
So I think
So, Your Honor, you won't consider a bond for her today? Is that
Isn't
my-
she being held in Eaton County anyways?
I do think she has a bond in Eaton County.
Yeah, no, she's got bond violations, 2 of them in here. Officer witnessed her himself in the bond violation. No.
She good?
I mean, my whole docket.
Everybody's disgusted. Everybody in jail for this one. Okay, let's see here. This is Mr. Matthew Christie.
Yeah.
Okay, 25-02579 appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Christie, who is standing to my right.
Okay, this is set for a contempt hearing and then final pretrial. We have witnesses here for the final pretrial.
Your Honor,
I think you waived the appearance, Your Honor.
That's what I'm trying to look at this.
yes,
Yeah, okay. I do see a note complaining witness to appear. How we proceed?
I defer to the defense counsel.
Your Honor, at this time, Mr. Christie would like to take the offer, which is trespass with restitution. The restitution amount is $1,150.
$1,150.
$15.
$15.
Yes, Your Honor.
Okay, we need a restitution sheet. We need advice of rights. And what is he intending to do with the bond violation?
It is my understanding, Your Honor, that he will not be contesting the violation. $15. Your Honor, may I approach?
Yes. matter with Mr. Zane. Okay, Mr. Christie, you want to plead guilty to trespass?
Yes,
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
yes,
Okay, you can put your hand there. Have an advice and rights and plea information sheet, that's your signature?
yes,
You went over these rights with your attorney, correct?
yes,
You understand that you have the right to the presumption that you're innocent, so you're innocent until proven guilty. You have the right to take this matter to trial and have the prosecution prove your guilt by proving each element of the charge beyond a reasonable doubt. You understand that?
yes,
You have the right to remain silent at any trial. They can't use the silence against you, or you can waive silence and testify if you like. You have the right under the confrontation clause to see, hear, or question any witness called to testify against you. The right to subpoena witnesses that will testify on your own behalf. Or you can waive your silence and take the stand at your own trial. Do you understand that?
yes,
You wish to give up all of those rights?
yes,
Is anyone threatening you to do that?
no,
The promises extended to you to get you to plead guilty.
no,
Are you on probation or on parole?
no,
You understand that by pleading guilty could result in a conviction that you may need to report to an employer?
yes,
And are you looking to plead guilty because you believe you're guilty of trespassing?
yes, I am.
As to the amended charge of trespassing, how do you plead?
Plead guilty.
Okay, you're not objecting to the restitution amount of $1,115, correct?
No.
Actually,
Mr. Christie, on or about August 22nd of 2025, were you at the property of 1914 East Michigan Avenue?
Yes,
And at that location, were you asked to leave, sir?
yes,
And did you fail to do that?
yes,
That's fine.
how did we get to restitution of $1,115?
At that location, did you destroy any property?
that's from where,
Um, However,
Oh.
we have had multiple final pretrial scheduled.
yeah,
Is that correct?
yeah,
Mr. Zaney appeared for those, the owner of that property, he appeared for those. You don't have any reason to contest that, do you?
no,
I think part of that, Your Honor, is Mr. Zaney's billable rate.
Oh, is that what the restitution is? It's
Yes.
not damage to property?
$125 of it is actual damage to the property, and I think that had to do with the screen. The rest of it is his
Like a
billable
screen
rate.
door?
Like a screen for a window, I believe.
Okay. And then the other is restitution for,
His billable rate.
I'm not following, you mean
So
restitution?
he
was-
had to appear to court multiple times.
Oh, got it, okay, I was trying to understand, was he a client or, okay, got it, okay,
It was missed wages, Your Honor.
okay, got it, okay. Should have set this for yesterday.
Right.
It was here. Okay, let's see, and as to the violation, The allegation is that he allegedly committed a retail fraud to February 22nd, 2026. You said he's not contesting that.
That is correct, Your Honor.
That's correct, sir?
Yeah.
Okay. And were you at the Walmart located at 3225 Center Boulevard, Lansing, Michigan on or about February 22nd, 2026?
Yeah,
And what happened that caused there to be police interaction?
I was with someone who was trying to shop with an air mattress, and so I was proceeded to be with them, so they took me into asset recovery, but they released me without charges.
It's interesting. It says shoplifting that occurred involving one person. Mentions nothing about another person. You was with someone else?
Yeah, I was with my friend.
It says at approximately 17:53, they witnessed an unknown female subject hand you listed item in sporting goods section. You then immediately concealed them under your jacket. Is that accurate?
Yeah.
So you're not being forthcoming when you said someone else was trying to steal.
It was both of us.
It was you. We're not talking about someone else. You concealed something under your jacket,
Exactly,
correct?
yes.
Okay, so you were trying to steal. Correct?
Yeah.
Any other factual basis?
But people are satisfied.
Okay. The court is satisfied with the factual basis. I'll accept your plea, finding your plea to be freely, voluntarily, and intelligently made. As it relates to the underlying charge, he's maxed out on his 30 days. Contempt is punishable by 93 days maximum. You can address the court.
Your Honor, until today, Mr. Christie had been forthcoming about what happened at these two locations, both relative to the malicious destruction that has been offered as a trespass today, as well as the retail fraud. He has also, I believe, spent some time now in custody. I would simply ask this court to give him credit where it can.
He spent time in custody because he refused to come to court. Not because he was sentenced on this. Like, do you know how long he's missed, how many times he's missed court on this? Do you have a job, sir?
Yeah,
Where?
I work commercial painting.
For who?
Jimmy,
Who's Jimmy?
my mom has got me an employer.
What's Jimmy's name?
My mom is in court, you know, I asked her.
No, if you work for him, you tell me his name.
I know
How old are
his name
you?
is Jimmy,
How old are you?
21.
You tell me who you're employed by.
Jimmy.
If otherwise, I don't believe you're employed.
I don't know his last name. I know his name is Jimmy.
How long have you been working for him?
I Start when I get released.
So you have not started, you never worked for him, correct?
Right.
Okay, so how much you gonna make an hour?
I think he's like 16 hours.
You think? Did you talk to Jimmy?
Talk to my mom, who Mike works with Jimmy as well. Mike's my
Who's
mom's
Mike?
my mom's boyfriend.
Wonderful. What address are you gonna live at?
704 South Acre.
Assuming you're the mother.
Yes,
Yes, you are very antsy in the backseat.
I'm sorry. I have it set up, so we're staying with the American's Best.
Ma'am, I can't understand what you're saying, I'm gonna be
We're
honest.
staying at the American's Best, and it's set up so that, since we have another kid that's traveling with us, he's a traveling type. And we're gonna be here for the next 5 months, and so it's, the kid that's working with him, I have set it up with his boss that he's going to get into another room, so he's gonna have 2 beds. He's going to be rooming with him, and then they're going to take him in and start training him, and as soon as he gets released, I have a job and a place for him to be set up. So he can pay.
Okay, so he's not staying at 704.
That's where I was staying prior.
Yes, that's where he was before, but he.
My question was not where were you
I
staying?
don't know the address to America Vet.
Okay, but I asked you, where will you be staying? So you're supposed to tell me the answer to my question.
Okay, I'm staying in America Vet.
Okay, and so, and how long do you think you'll be staying there?
5 months.
5 months?
Yeah,
And you set it up, what's your name?
my name is.
Nicole?
Yes,
Okay, and you're his mother? Your last name is Christie?
Brown.
I'm sorry?
Brown. His name is
Brown.
Chris.
Okay, and so you've made arrangements for him to work with someone named Mike or Jimmy?
Mike is my boyfriend. Jimmy Carroll is his boss.
Okay, and Jimmy owns a company?
More or less. They travel and
They travel where?
we were in Kentucky and, for a while, before that, Georgia. They come up north in 5 months, well, around September, we'll go up to Grayling. And then once the snow hits, we'll go back down south and it's just like.
Okay, got it. And so you're taking your son with you?
Yes.
Okay. How are you gonna pay your restitution?
I'm gonna pay it with coming out of my paychecks. Up to-
We need a payment plan. When are you gonna make your first payment?
and,
Why not?
We'll be getting paid daily and a portion of that will go to restitution, whether I have
So I
to
can make
boss do it or.
I can make a payment for Wednesday, Thursday,
Of how much?
$100.
You're gonna be able to pay $100 Thursday of this week?
Yeah.
And then you're gonna pay how much monthly?
500.
Are you positive? Your mom is not positive.
How much are we make? 300. 300 a month.
Pay $300 a month.
Yes.
Okay. The problem is if you say that and then you don't, it goes to a show cause and then warrant. Versus if you say, I'll pay $100 a month, or I'll pay $50 a month. So I'm trying to understand,
So,
are you really going to pay $300 a month, or are you giving me lip service because you think that's what I want to hear? I don't. I want to hear how much can you reasonably pay? Because you have to put a roof over your head. You don't even know
Yeah, 100.
how much work you're going to have yet.
we're gonna start with 100 a month.
If for whatever reason you require an extension or an adjustment to your payment plan, it is your responsibility to contact the court. I'm saying that so your mom can hear it, so she can remind you, because you have a issue with remembering court dates and responsibilities. You've missed court on this file 1, 2, 3, 4, 5 times. And it's always you wasn't aware or you can't remember. You're gonna have to remember your payment plan, because you could get landed back in jail because you didn't make a payment. And that's unreasonable. Remember your payment plan. If you need an adjustment, you call or contact the court and request an adjustment, okay?
Okay.
Credit time served. Any additional matters for the record?
Nothing wrong with you, Your Honor.
Nothing with that. Thank you. Your Honor.
You're all set. Okay, let's see, who shall you bring up for Miss Estrada? Who would you like next, ma'am?
We have a complainant witness.
Oh, for
Wyman.
For Wyman? Let's bring Wyman up. Actually, because I skipped Bates, we don't need Bates.
Okay.
This is the state of Michigan versus John Lee Wyman, 26-01280. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf.
Assistant Public Defender Justice Straub on behalf of Mr. Wyman, who is standing to my right.
Mr. Wyman, you have an assault and battery pretrial today, and then also a bond violation, alleging that he had third-party contact with the protective department. How are we proceeding today?
Your Honor, we will be contesting the violation.
Was there an offer?
There's no offer, Your Honor. People are prepared to move forward with the PA 53 violation.
Today?
Yes.
So you want a final pretrial on the other matter, or what do you want? The trial?
We can set for trial, Your Honor.
You call your witness.
The people call Stephen Collins.
I am gonna bring things up after this.
Let me tell them.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
You can have a seat, sir. State your first and your last name and then spell both.
Stephen Conklin, STEPHEN
You can proceed. Counsel.
Thank you, Your Honor. Mr. Conklin, I'm going to ask you a couple questions about an incident that brings you into court today. So, give me a second. Start off by asking you some questions about this matter that took place on May 15th of 2026.
Okay.
Are you familiar with that date?
Yes, I am.
Okay. Is there's and there was a underlining issue that brought you to court before that particular date. Do you remember that incident? The assaults?
Yes.
Okay. There's someone here that you filed assault claims on prior to this May 15th incident. Can you point that individual out and describe an article?
John.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection? So noted.
So there was a previous assault claim that you filed against the person, right?
Yes, sir.
You remember what date that was?
3 days before the people showed up in the house.
Okay, so prior to the people showing up, this particular incident, you filed an assault charge.
Yes.
And to your knowledge, strike that. So tell us on May 15th, were you at 1822 Rex Street in Lansing? And is that your address where you live?
At that moment, yes.
And can you describe how you came to live at that address?
After speaking with John, John offered me a trailer for rent that was in his backyard at the time. I was eventually moved into the 1 bedroom and then it moved to 2.
2 bedrooms in the trailer,
No, in the house.
in the house. Okay.
Yes.
And then on sometime before May 15th, John assaulted you, right?
Correct.
And then on May 15th, after you filed charges for assault, tell us what happened on May 15th.
I left to go to the store with my kids. I came back, tried going into the back door. Wouldn't work.
And you have to keep your voice up a little bit because the judge.
Tried going into the back door. It wouldn't work. Stepped out. There's like a little breezeway right there. Stepped off the back porch. John's truck pulled up. 2 gentlemen stepped out. 1 Hispanic, 1 white.
And you said John's truck pulled up. Was John in the truck when?
No.
It pulled up? Okay, cool. But you recognize it as John's truck.
Yes, sir.
Okay, all right. Tell us what happened when it pulled up.
There's 2 people started being belligerent, basically demanding I leave, threatening to hit me in the head with a hammer. Wouldn't let me go into the house once they went in. Basically refusing me to get my stuff after begging them to be able to go in and get my stuff. I therefore spoke with my family member, which heard everything going on. And then they called the cops.
And these 2, you said there was a Hispanic individual and you say what, Caucasian individual?
Yes, sir.
Did you recognize those people before? Had you seen them before?
I had seen one in passing, was dealing with different incidents, but no, I have not had relations or dealt with them.
How'd you know that the defendant sent those people to that address to confront you?
The 2 people informed me that John sent them over there in his truck, and that John had full intentions of coming back to that address when he got out of work.
In order to remove you or to kick you out?
No, I was supposed to be already gone,
Okay.
according to these 2.
Okay, so to prevent you from getting back into the.
Yes, sir.
Okay. And this all took place in the city of Lansing, right?
Yes, sir.
Ingham County, state of Michigan?
Yes, sir.
All right, thank you. No further questions.
John Peter.
John is his associated friend,
Okay, how did you come to meet him?
met him through social media.
Okay. And so tell us how you go from social media to moving into his home.
We talked, he was informing me of some poor things or some bad things that happened in his life. I was informing him of some bad things that happened in my life. Told him that I had my son, and he had offered me the trailer out back, and I did not move on that until 3.5 weeks after.
Okay.
Then in that 3.5 weeks, it had went from the trailer to a bedroom. And then he had another person living with him, which that was going to be his stepson. He went to jail, and then it moved to 2 bedrooms.
Okay, so when you moved in, you didn't move in directly into his home. You moved first into a trailer.
No,
Okay,
no. The trailer was offered.
okay.
Within the 3.5 weeks of me waiting to move in there,
Mhm.
I had to fix my truck so I could work to be able to pay him. He had changed to the trailer to inside the house. When me and John were talking, I said, "Oh, I must have upgraded."
Okay. Oh, so he was kind to you. He offered you
Yes,
a better circumstance. Okay. And how much did he charge you for that?
400.
Okay. And did you ever pay that 400?
Yes, it did.
I'm gonna object to relevance.
Just around this.
I see. what you're saying.
There's an objection to relevance, so you don't have to respond until I instruct you whether or not you can give the answer or not.
Part of the defense's theory, Your Honor, is that Mr. Wyman was simply availing himself to the benefits of the law through an eviction process.
By sending 2 people over.
Whoa, 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 whoa. What lawful eviction allows this? I'm confused.
So, Your Honor, we are contesting actually that Mr. Wyman sent two people. We actually have a video of the proof of service. We also have another
Proof of service of what?
of the 7-day writ, Your Honor.
Okay, so you believe that your position is that there was proof of service of an eviction,
Yes,
okay, and that there, and then what? What does that have to do with whether or not you pay the rent?
that there was a basis for the eviction as
Well, you
well.
don't, in the state of Michigan, you really don't need, you can do termination of tenancy because you just don't feel like having them there. So that, whether or not you pay the rent is irrelevant. So he doesn't have to answer that. But I'll let you ask whether or not he was served with a notice to vacate.
Okay. Well, let's jump right to that, okay? Were you ever served with a 7-day writ, Mr.
The
Costa?
same day
Okay.
that them two gentlemen came over,
Mhm.
one, the white Caucasian gentleman,
So
was
I
the
would've-
one that came the second day morning
I would
and
object,
served me a 7-day notice.
It helps when you stand up. It makes him feel like you've got something to say.
I would object to this entire line of questions for relevance. We're here because the defendant committed PA 53 violation. And I don't think an eviction has anything at all to do with uh, PA 53 violation, or him sending two people over to the house to contact this witness.
Objections overruled. Because if, and I don't know what she's laying foundation for now, if she's just trying to lay foundation to establish that someone was sent there to serve an eviction paperwork, that is within the realms of, he's allowed to serve an eviction on his property, even though this is pending violation for him, or pending violation for him to have no contact directly. Court order will allow him to send someone to serve that paperwork. However, this sounds like it was more than just service.
Yes.
Okay, so you said earlier in the day. Could you, 10:30?
10:30 in the morning, the Caucasian gentleman showed up at the door, banging on the door. I opened the door. He served me a 7-day notice. Couple hours after that, he come back with the other gentleman and then wanting to force us out of the house. I didn't know that the Caucasian gentleman was the one that sent it until he informed me he was the one that served it.
Okay, so someone who showed up later in the day,
The same person.
you weren't aware that.
Are
he
you
was
not
the
following
same-
me? Okay, let me say this again for you. A white gentleman showed up at the door, 10:30 in the morning,
Mhm.
served me a 7-day eviction. That same white gentleman
Mhm.
appeared later in the day with an Hispanic gentleman to have me removed out of the house by their way.
Okay, I appreciate the clarification. You just said that you didn't know that one of the gentlemen that came later in the day was the same gentleman. Who
Now you're
served
playing
you.
on my words because no, I didn't know. I said he made me aware that he was the one that served me when he came back the second time.
Did you or did you not know it was the same person when he came back the second time?
I didn't recognize Noah's in the morning.
Okay, well, she's not playing on your words. That's exactly what she just asked you.
No, I didn't recognize him at first. Then he informed me he was the one.
Okay, so if I were to show you an image of that person, would you be able to identify them as the person who appeared at your home
Yes, I
earlier?
will.
today? And you said that was at 10:30,
Approximately correct.
Your Honor, permission to approach the witness?
I haven't had an opportunity.
I'm sorry. It's still shut here. Okay, do you recognize that house?
Yes, I do recognize that house. I cannot recognize that gentleman. I'm facing. This
Can
is
you-
the picture
excuse
behind.
me,
Yes,
Mr.
that
Conklin.
is
So, yeah,
1822.
sir, you can only answer the
Yes,
questions that are
that is
asked.
1822 Rex Street.
I appreciate your testimony, sir.
Mhm.
I'm going to ask you at this point to answer my questions with yes and no responses,
Yep.
okay? So this is the home that you were living in at the time?
Yes.
Okay. Does this appear to be the person that you saw that day?
I cannot answer that question.
You cannot recall?
I cannot answer that question. That picture is taken 20 yards from the house and it's on the backside of it. I can't answer that question.
Well, let's play the video a little further. Let's see if maybe you can get something that helps you become more familiar. Bear with me, it's just a minute and 44 seconds. Looks like someone has opened the door.
That would be it.
So you do recognize that name.
No, I did not say it.
You said that would be you, sir.
No, I did not. I said answering the door would be me. I cannot recognize that gentleman from the backside. I don't know. As far as I know, that picture
Sir,
could
there's
be.
no question.
Okay, so when the people showed up at, you said 10:30 in the morning, were they in possession of any weapons?
No.
Did they interact with you any more than simply handing you a piece of paper?
No, they did not.
Okay,
They were quite respectful.
okay. You say showed up later in the day. Did you ever get a chance to get their names? No? Okay.
No, no, I did not.
Did you ever actually see them in possession of any weapons?
No.
Okay. However, you mentioned that they had threatened you earlier.
Correct.
Okay, but they never had any weapons.
Objection, I don't know. I will ask. Just because they don't have a weapon does not mean they can threat, right?
Well, by his very testimony, he said they threatened him with a hammer.
Oh,
No.
He said, when I'm dealing with an objection, you can't respond, sir. It requires me to address the objection and then tell you if you're lawfully allowed to answer the question or not, okay? There's nothing to do with you, it has to do with the question, okay?
Correct.
Okay. The objection's overruled. You can answer the question.
Never saw anyone in possession of a hammer or a gun or any weapons.
I never did see anybody in possession of a weapon.
And you did not see my client that day, you mentioned that as well.
Correct.
Okay, then how are you 100% sure, this time you can answer something other than yes or no. How are you 100% sure that Mr. Wyman is who sent them?
The two individuals informed me by verbal communication that John sent them over there to have me removed out of the house by them, let it be them hitting me in the head with a hammer or by other body in front of my children.
Okay,
That's how I know.
so it could very well be that that was not the truth. You never heard from Mr. Wyman yourself that he had sent people over to your home.
No,
Thank you. No further
Can you
questions.
redirect? Thank you. So you may be excused from the stand. Thank you.
can I go back up?
Or you can stay here. It's up to you.
Oh, no.
You have any other witnesses?
no, the people were.
Argument. Are
Oh.
you calling witnesses?
I do have one witness. Your
You do
Honor.
have a witness?
I do.
Oh, okay, good.
Defense call Michelle Horton to the stand, please.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes,
Thank you. You can have a seat. If you can state your first and last name and spell both.
Michelle Horton, MICHELE, HORTON.
You can proceed. Thank you.
Just for context, Ms. Horton, how do you know, or who are you to Mr. White?
I've been friends with, best friends with John Wyman for over 20 years
And how are you involved in this situation?
because John ended up needed it when he got out of jail the first time. He needed a place to go because he couldn't go back to his house.
Okay, and on May 15th, how would you have been at all related or involved in anything that happened at that Rec Street address?
The only thing that I know of is that I rode over with Melzer to give the 7-day notice or whatever, and I videoed it.
Okay,
That's the only part I have of it.
so how long would you say, well, let's start with, what time do you think you would have arrived? To the best of your memory.
I'd say it was, but I would say it was about 11, because John had to be to work that day.
Okay, so when you arrived, how long would you say you were there?
Probably maybe 10 minutes, because it took us that long to get him to answer the door.
Okay. And how many times that day did you go there?
Pardon?
How many times that day did you go? to
I
that
only
address?
went once.
Okay. And were you aware of any instruction from John to go back to that address later in the day?
No, I was not.
Who was Mr. Melzer? You just mentioned a Mr. Melzer. Who is that?
Clint Melzer.
Who is he?
He is a friend of mine and got to be a friend of John's for a minute. And when John got out of jail the first time, and John wanted to go get the 7-day notice, we rode down there with him to get it. I didn't go in with him. Clint did. And then the last I knew, he was supposed to be door dashing.
Okay. So Mr. Melzer is the person that went with you to serve the notice. What role did he play in that service?
He went to the door and handed it to him.
Okay, do you see Mr. Melzer here today?
No, I don't.
Okay. Your response it seemed to have some humor to it. Why
Well,
is that?
because Mr. Melzer's in quite a bit of trouble.
Why is that?
He stole my laptop computer. Him and his girlfriend, Alicia Matea, stole my Norco strips from Kroger's, and they were caught. She was caught on camera. I identified her. So she's gonna go up on charges for that.
What's the relevance?
Yeah, objection.
What is the relevance to this case? A bond violation?
Well, Mr. Melzer, Your Honor, is now accused of stealing Mr. Wyman's truck. He was previously given the ability to drive that truck, but for very specific purposes, he has not complied with the scope of that
What's that
authority.
got to do with this?
Because we're alleging that Mr. Melzer went back to that property, if he did that, on his own accord.
You want me to believe that Mr. Melzer cared so much about this person's property that he took his truck to his house to do a vigilante eviction because he just had nothing else to do?
No, Your Honor, I am saying that Mr. Melzer may not be the most
Mr. Melzer's not here. Mr. Melzer's not on the stand. We are not assessing his credibility. It's her credibility at stake right now because she's testifying.
He was subpoenaed to be here today, Your Honor.
Why are you questioning her about something that has nothing to do with this? It's not relevant. Move on.
Okay. Where was Mr. Wyman's truck after this incident? Who was in possession of that truck?
Clint Melzer.
Okay, and where was that parked?
It was parked at my house at 306 Brittany, and he was told not to drive it because John.
Objection,
Hearsay.
objection. Yes.
No further
Sustained.
questions, Your Honor.
Miss, I'm sorry, what did you say your name was?
Michelle Horton.
Horton, Miss Horton, were you at this property house where you served the eviction. You were there earlier in the day, right?
Yes,
You weren't there later in the day
no,
when this incident was alleged to have happened,
no.
right? Okay, no further questions.
Maybe excuse me, thank you. Any other witnesses? Any other defense witnesses?
Yes, Your Honor, Mr. Wyman.
Raise your right. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can examine him from there.
Mr. Wyman, did you send someone to the Rec Street address for any purpose on May 15th?
To be served. With
For
a
what?
7-day rec.
Okay. For any other purpose?
No,
Did you instruct anyone to threaten Mr. Conklin?
no,
Did you ask anyone to go to that address more than once?
no,
And you didn't go there yourself either, did you?
no.
No further questions. Cross-examination.
You are Mr. Wyman. Mr. Wyman, I'm Dan Smith, I'm the prosecutor. I'm gonna ask you a couple questions about your testimony today. If you don't understand the question that I give you, you can ask me to rephrase. If you answer the question, I'm gonna assume that you've understood the question, you're answering that question. Comfortable with that?
Yes,
You agree on that?
yes.
So, Mr. Wyman, it sounds to me as if this matter arises over a property dispute, right?
Yes,
And you say that Mr. Conklin was supposed to pay your rent.
that is correct.
He didn't pay your rent,
That is correct.
and you wanted him to leave the property,
That is correct.
and he didn't leave the property.
That is correct.
So that made you upset.
I had to serve him.
My question is simple.
Yeah.
It's just yes or no.
No.
You didn't leave the property. You weren't upset that he didn't leave the property after not paying?
No,
Okay, so you just let him just stay in there, right?
Yeah.
So you didn't issue a writ.
yes, it was issued.
My question to you is, were you upset that he did not leave your property after not paying rent? Yes or no?
Objection, Your Honor, asked and answered.
Okay, so,
Are you withdrawing your question?
no.
Oh, okay. The objection's overruled. You can answer.
So again, my question to you was, you said you weren't upset with him leaving, but you issued him so you didn't think that he should continue to stay, right?
Correct.
So you issued a writ,
Correct.
and you had your friend go over and serve that writ
Right.
in your truck
Correct.
with some other.
Not serve it. He didn't serve it in my truck.
You had your friend go over and serve a writ, right?
With Miss Horton
With Miss
in
Horton.
her vehicle.
You take that, right? And she take that,
Mhm.
and
Is that a yes?
Yes.
this friend that you had go serve the writ earlier today, does he have access to your keys to your truck at all times?
No,
So on this particular occasion, he got access to your truck
yes,
without your knowledge.
yes.
Where are the truck keys located?
Miss Horton.
And Miss Horton's your friend, right?
Yes,
And he got the keys to your truck.
Yes.
And he got another one of your friends, this
No,
Oh, okay.
I don't know.
So you got the keys to your truck after serving the writ. The guy who gave him the writ earlier in the day.
Yeah.
He got access to the keys to your truck.
Yes,
You went back to your property.
I did not know.
You heard his testimony.
Yeah.
So he's testified that they came back to the property. Did you hear his testimony? Were you here sitting in the courtroom? You heard his testimony, right?
Yep.
His testimony was that your friend, who, how long were you friends with this guy?
A day.
I'm talking about the person that you sent over to issue the writ who came back in the day. Were you only friends with him for one day?
Yes,
You let a person who were friends with one day get the keys to your truck. Is that your testimony?
yes,
Okay. And you let this friend serve a writ for you on your behalf? Somebody you didn't know?
correct.
Okay. And you authorized Miss, what was her name? You authorized her for that guy to get the keys to your truck?
Yes.
Okay. A person that you didn't know. You said, hey, take the keys to my truck, no problem. Go issue this writ for me. Is that your testimony?
Objection, Your Honor. I'm not sure what the relevance here is to the truck.
It goes to his credibility.
This definitely goes to credibility,
For who, Mr. Melzer or for Mr. Wyman?
Mr. Wyman.
So do you need me to repeat the question?
Yes.
My question is, you let a person who you had no clue who this guy was, right?
Correct.
You authorized him to get the keys from Miss Melsner,
Miss Horton.
Miss Horton. You authorized him to use your vehicle that day.
I was dropped off at work.
Do you remember the question?
Yes.
The question was, you authorized that guy who you didn't know to get the keys to your truck to go issue a writ, right?
No.
No, his
So,
testimony
okay,
was that
so-
the truck wasn't used to issue the writ. They
Okay.
went in Miss Horton,
Miss Horton.
Miss Horton's vehicle to
Okay,
issue the truck.
first, okay.
Then he later gave this person that she testified they had became friends, but he said he has now testified that they just met each other. He gave the car to his truck to him that day
Okay.
for whatever purpose.
So, some time later, this person that you didn't know got the key. So he didn't have keys to your truck earlier, but sometime later in the day, he got the keys to your truck, and you heard him testify that that individual went back over to the house and threatened.
Yeah.
Right? And this person that you did not know and who did not know the guy who testified went, or it's your testimony that that individual went back to the house to threaten this person, and it wasn't at your request.
That is correct. It was not at my request.
And do you believe that that testimony is reasonable? Do you believe it's reasonable for a guy who didn't know him, didn't know the complaining witness, and who doesn't know you, would go over to a house and threaten someone because he didn't pay you rent? Is that reasonable?
No.
Oh, I agree. It's not reasonable. No further questions.
Can you redirect?
John, was Flint a mutual friend between you and somebody else?
Yes.
So it wasn't like you had just met him the day before on the street, right?
Right.
Okay, so you kind of had a reason maybe to, I want to say trust, but to believe that maybe giving him.
Are you asking him a
I'm sorry.
direct question or a leading question?
I'm trying to ask a yes or no question.
This is your witness. You can't ask him a yes or no question. So it's, did you have a reason to trust him versus suggesting the answer?
So did you have a reason to trust Flint?
Yeah.
Okay. And you were dropped off at work, correct? That's before the service. They used your truck to use. Why? How did you get to?
I drove my truck to work.
And then how did your truck go to?
Because he,
Your Honor, I didn't hear the question. I'm
How
sorry.
did it get to,
How did your, after you went to work, how did your truck get to?
he,
I would say objection, cause for speculation.
Your Honor,
how's his truck? I think he should know how his truck got there. I'm gonna rule that objection. You can answer the question. Is that the person's name?
The question is after John
Yes, not in the
drove.
report, Your Honor. Yes,
How-
his name's Clint.
Yeah.
Okay, who is Clint?
This,
I don't know. That's what I'm at.
the person who served 70 rep.
the person that,
Okay, this is causing confusion because 7-day writ was not served in the truck, correct?
Correct.
no, Your Honor, I just want to
Oh,
clarify that Clint is the individual that Mr. Smith was just saying, questioning as to John's credibility as to why he would give him his keys.
I think it was another person. I thought.
No, it was Clint.
It was Clint. What's Clint's full name?
Clint Melzer.
Okay, let's use it. Let's be consistent with the name so we don't get confused because there are two males alleged to be involved. So so it's the same person you're talking about.
I guess. I mean, I didn't know who the person was, but.
Clint Melzer. Okay.
Clint Melzer.
So my objection is a call for speculation because it says he was dropped off at work. And I don't believe there was a foundation for him to say how the truck got, well.
Did he give him?
You're-
I thought he
you're-
was allegedly giving his truck to the person.
Your Honor, if I may, so the prosecution is essentially saying that.
The objection's overruled. He can answer the question.
So after you drove to work, how did Clint get your truck?
After I was dropped off at work, he asked if he could use my truck to do DoorDash. That's the last I knew.
Okay, did you ask him to go do the service along at any point?
That was earlier with Miss Horton.
Okay, so after, I just want to make sure the timelines are, right. So after Clint Melzer had performed the service, you allowed him to go use the truck for,
Yes.
no further questions, Your Honor.
I have just a couple follow-up questions. If everyone's referring to a writ, you had a lawful eviction that was in process during that time?
Yes, it was.
Okay, and a writ had been issued?
Yes, it was.
Okay, and so did you tell law enforcement that you were of the understanding that you could tell Mr. Melsner and the other person to go lock your property up to secure it?
Yes.
So why are you now acting like you didn't know that they were going over there?
Mr. Melsner went over by himself to lock my doors, which he did. Nobody was there.
How do you know that?
Mr. Melsner said that to me.
When did he go over there by himself to do that?
After I was dropped off at work,
You sent somebody back over
I
there.
asked him to go and check
Thank
to see
you.
if anybody was there. I locked my door.
Argument.
I think it's clear, Your Honor, that at any rate, that the defendant could have used the police if he had a lawful writ, or if he was under the eviction process. There's a right way and a wrong way to do it. You don't send your friends, a person that you trusted with your truck to use DoorDash, and now you're coming to court saying that this might have been a friend or wasn't a friend, or he did this on his own. I think it's clear. The defendant claimed that his own story wasn't reasonable. It's not reasonable to believe that the defendant did not send them back over there to do self-help and to lock this place up when he should have used the police. So based off of the testimony that you heard in the credibility of this witness testimony, I'm asked that you find him guilty of the PA.
That's strong.
Actually, I might just not do this, yeah.
Thank you.
Your Honor, I don't think it is the service that is in question. I think that what the prosecution's theory is that later in the day, when these two men, who one of them is presumed to be Clint Melzer, we don't know because the police report does not accurately identify who exactly the two men were. That's kind of what we're inferring based off testimony from Mr. Congress. Now, Mr. Wyman has a fundamental right to pursue an eviction process. There is a genuine question as to whether Mr. Conklin was even legally allowed to be at Mr. Wyman's residence.
Not in this case.
So, well, after, we would say that after, I'll move on from that. As to Mr. Conklin's credibility, this is an individual, so Mr. Conklin, the complaining witness in this case. So from the police report, what we know, and from Mr. Conklin's testimony is that when the two men arrived to do whatever they did at the house, which we're saying that John did not ask them to go there. Not,
You just told me he sent them.
what we're saying, he did not send them there to threaten. So
He sent them there, which is a violation. That third-party contact was not allowed. He had already served them. He then sent somebody back over there at his direction. The testimony is that he said, that Mr. Conklin said, is that Mr. Wyman sent him over there to lock the property up and get him out of the property. That was the testimony that he gave.
Your Honor, if I can continue, what we would draw into question is Mr. Conklin's credibility as to what actually happened. So I just want to like go through a little bit. So around 6:25 p.m., this was when Mr. Conklin and his kids returned. He asked, this is from the police report. He asked permission.
We
to go
can't
into-
testify from a police, you can't give argument from a police report to
Well,
me.
I'm
You
talking about
cannot
from
give
the-
me argument on a police report.
Okay, I'm sorry, Your Honor.
Yeah, that's not evidence.
I'm talking about.
You can only give argument on the evidence that was brought forth.
So from the testimony, Mr. Conklin is saying that these two men had threatened him with a hammer. He did not see a weapon. There was no weapon involved. There were no threatening, no threatening statements really.
There was a threatening statement. He said that they threatened to use a hammer. They said we will hit you with a hammer. He did say that they didn't see the hammer. He did see a hammer, but threatening statements were made that based on his testimony. So that argument is not accurate as it reflects the testimony that was brought out.
And that's Mr. Conklin's testimony. We would argue that Mr. Conklin had a financial motive to fabricate or exaggerate claims. There's a financial motive to have my client locked up so that he can stay in his house rent free. That is essentially what happened in this case. And Mr. Wyman, he was a vulnerable individual during this encounter, just lost his husband not long ago. I believe that the situation.
Who is this?
Mr. Wyman, my client. So I'm just saying, I believe that this was a situation of a vulnerable person being taken advantage of. And I just think that the complaining witness here has a motive to fabricate.
Okay. You don't believe though that your client also has the same motive because this is his property. He owns it, correct?
Yes.
No,
rents.
he does not.
He was living there. He
Yes.
doesn't own the
He
property.
does not own the property.
Well, how is he doing an eviction?
It was a very imperfect process, Your Honor.
He doesn't own the property.
He does not.
How is he doing an eviction? How does he have a lawful right to serve a writ? You just argued that he had a lawful right. You told me that.
Rents the house.
You told me he had a lawful right in your argument. He doesn't own the property.
He has a lease.
No,
He has a possessory interest, Your Honor.
yeah. How are you have a lawful right to issue a writ on somebody?
Your Honor, we don't believe the process that Mr. Wyman used. He was doing this honestly.
So it wasn't lawful. It was very vigilante.
Very imperfect.
It was very
intent wasn't to
vigilante.
be an
I've heard
eviction.
enough. I've heard enough because I 100% believe that Mr. Wyman sent someone over there to lock this man out of the property. This has nothing to do with whether or not he was vulnerable. This had nothing to do with whether or not rents had been being paid or whether or not he had a lawful right to sublease. That really has nothing to do with that. This has to do with the fact that before me, he was arraigned. He was told not to go back to that property. He told me he was going to be staying with his father, gave me the address of 1508 Redwood. He wasn't staying with his father. He was staying with her. He then decided he was going to execute a writ or issue a writ and have this man removed so that he can get back in the property. That's what this has to do with. And after the writ was served, because she has already testified that she's gone and with someone else and recorded serving the writ without issue. If he had to let it stay there, he wouldn't be in this position. He then later sent someone back over there with his truck. He told me, that's why I asked the question I asked, because he evaded it when he was asked on direct. He evaded it when he was asked on cross. You're not going to evade it to me because I know what it was alleged that you told the police. And you allegedly admitted to the police that you sent the guy back over there. That's why I asked you that. Oh yeah, I did send him over there because I thought, yeah, that's not what you said when you were asked by the prosecution. You said you didn't know he was going back over there. He did know he was going back over there. And if you are engaged in a criminal action and there's a no contact order, and you then are moving forward with a lawful eviction, you must use a process server. Not some vigilante person you may or may not know, because one minute you say you don't know him, you just met him, next minute you do know him. The other person would say he's a mutual offense, that he's a criminal and he stole from. You definitely don't send them. And you definitely don't do a lockout. If you serve them with a writ, giving them 7 days, you can't now go lock the property the same day. So I'm sustaining the violation because he absolutely violated the conditions of the no contact order. Why is your hand raised? You should talk to your attorney. You can address the court once sentencing on the violation.
Your Honor, admittedly, Mr. Lyman has not availed himself to the courts in the way that we would expect him to, or by the rules of the court. It has been shown multiple times today that he is a very trusting person, and he doesn't necessarily have all of the faculties to go through this process in a legal and lawful way. I do believe that he is apologetic about that. We would ask this court to consider time served today. I do think he's been in custody now since the 15th of May. Thank you.
All right, want to make a statement?
Your Honor, I served him the writ and I sent Mr. Meisner over to lock my doors because he was not there, but I did not.
How'd you know he wasn't there?
Because Mr. Meisner came back and informed me that the house was locked.
If it was locked, why are you sending someone to lock the property?
He went over to lock the doors and then he came back.
How did you know to send someone over there to lock the doors?
How did I know?
Yeah. If you don't live there, you don't have communication. How would you know if someone's in the property or not?
Because I told Mr. Meisner, if there's a vehicle there, which was Mr. Conklin's, to not enter. And the vehicle was not there, so he entered that property because
Unlawful contact.
Mr. Meisner.
Unlawful contact.
But I did not send them, I was unaware that they went back.
Well, you sent them back, so you sent them to go lock the property.
One person, not.
Doesn't matter, you can't send anybody.
Right.
You couldn't send anybody, do you understand that?
Yes, I do.
You're not allowed to send anybody.
Yes.
No third-party contact.
Yes, and I was unaware of that.
No, you were aware that there was no third-party contact. It says it in your release form.
I did not get a release form.
We went over your bond. I arranged you myself. I know what I said.
All I got was paperwork.
No contact, directly or indirectly, is what I said. And I signed the bond order. You didn't tell me you left the jail without a copy of a bond order. They don't do that down there.
All I got was a piece of paper that said I was due for pretrial. That was all I got.
There, and a PA 53 form was attached to it.
No.
They don't release you without a PA 53 form.
Okay.
You told the police that you thought it was okay to send somebody over there to lock the property. This was after the writ was served. I would have let you slide on sending someone to peacefully serve the writ. But sending somebody back over there to check to see if the property is vacant, and if there's a car there, leave. If there's not a car there, lock the door. You don't even know if he went to the store. You were doing a vigilante eviction, and you were trying to lock him out the property. And you can't make people leave anything other. I find that you did lack credibility when you tell me that story. I'll give you credit, time served. You've been sitting in jail for 30 days for this, or yeah, just about. So I'll give you credit, time served. I don't want to have to reiterate your bond conditions to you. Do not try to mince words with me. I arrange you myself. I say it like clockwork. You cannot have contact directly or indirectly with the protected party. At no time when I arrange you, did you tell me, well, Judge, I have a pending court case with him because I filed for an eviction. You didn't mention that. Am I allowed to have someone serve him? You didn't do that. At which point we would have directed you on who specifically could serve him. You didn't do that. You didn't mention any of those things. You also told me, I asked you, where will you be staying? We'll stay with my father. You, per your bond conditions, have a requirement under the order to make sure I know where you're staying. And if you change it, you got to let me know in writing. Did you tell me you were going to be staying at her house?
I stayed at Miss.
Did you tell me, I'm telling her, she already testified you had been staying with her. Did you tell us that you were staying somewhere else?
No.
You probably ain't never stayed at your father's house since I let you out.
I was only out 2 days, ma'am.
I arranged you on the 13th. When did this incident occur? On the 15th. On the 15th. You didn't stay, you said you were gonna stay at your father's house. That's not where you went.
Right.
You went to go try to do a vigilante process so that you can get back in the property.
No.
Yes, you did. Go back and forth with me again.
No, that's okay.
That's smart. You're not allowed to have contact directly or indirectly with this protected party. That means you can't send anybody else to talk. You can't send anybody else to go check on him. You can't send anybody else to go stare at him. You can't send anybody to go lock any doors. At this point, he's testified that he's out of the property.
I understand.
And so you are allowed to return to the property if you're still a lawful renter or leaseholder on that property, because he has testified he's not there anymore.
Correct.
But that still doesn't allow you to have any communication. Correct. Directly or indirectly. If he's at Burger King, you go to Wendy's. If he's at Kroger, you go to Meijer. You understand that?
Yes, ma'am.
There should be no confusion at this point, correct?
Yes, Your Honor.
Is there any other potential court cases that you have pending with him?
No, Your Honor.
Okay, any other reason why you think you might want to try to send someone to check to see if his car is there?
No, Your Honor.
Okay, any additional matters for the record?
Nothing from the people, Your Honor.
Not from defense, Your Honor.
Okay, you should be released today. You're all set.
The jury trial,
Thank you, Your Honor.
Jury trial date,
August 25th at 8.
August 25th at 8 a.m. in person at the court. David, I'm gonna need a new bond for him because he's gonna return to the Rex address.
Oh, yeah.
Then when you go back, you can bring Bates up.
Thanks, okay.
Let's see. Mr. Amadeo is here.
Morning, Your Honor.
Okay, and you are representing Marie or Taylor Little?
That's correct, Judge.
Okay, this is the state of Michigan versus Taylor Little, 25-00247 appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Tara Little. We both consent and appreciate being on Zoom. Taylor, please state your name for Judge Simmons and her staff to know it is you on Zoom.
Taylor Marie Little.
Thank you.
Okay, this matter was scheduled for assault and battery, and I know we recessed this because you had recently been conflicted on the case. Let's see, was there an offer yet?
There's no offer. I believe me and defense counsel have had a few discussions, but we've made no offers. I asked this matter be set for final pretrial. Give us time to come to a resolution.
I have no issue with that, Judge. Just for the record, though, she has a felony prelim in your court in 2 days, which is not mine. So I was waiting to see what happened with that. I just found out about the other file, and obviously that would take priority over the misdemeanor. But I'm no issue kicking it out for a final pretrial. That's what the court and the people desire.
Final pretrial, July 14th at 8 a.m.
July 14th at 8 a.m. for final pretrial, in person at the court.
Jury trial, August 25th.
August 25th at 8 a.m. for jury trial.
Thank you, Judge.
No problem. Ms. Little, do you have any questions today?
No.
Any additional matters for the record, counsel?
Enough from the people.
Not from the defense, Your Honor. Thank you.
Thank you. Someone was in the
Thank you.
jail. I had to break out room. Let's bring him back.
I know. Or say that you should have had enough.
Yes, it's just not important. Did the jail leave? Oh, maybe it's just a delay. I don't know. I don't see them anymore. I don't see anybody. I just try to bring them back. Who's on the iPhone?
Pardon, reader?
Oh, there's the jail. Who's in the jail? Is that Davis? Jalen Davis? Everyone else is on a rent. Okay, I don't. So that must be it. This Mr. Davis?
It is.
Okay, are we ready with
Yes.
Mr. Davis?
Your Honor, I would actually like to speak with him.
Okay, Mr. Davis, your attorney's gonna log in just a moment to meet with you. For the person on the iPhone, there's multiple. And someone's on a Motorola. What's your name, ma'am?
Jaquel Gibbs.
That's your 12 Gibbs.
I believe that's his mother.
Well, why in the world is she in my screen then? Where is Jaquel Gibbs?
I'm right here.
Let me see Jaquel Gibbs, please.
Just one moment. How you get to your picture? You want to see your picture? How you
Grandma double tap the screen and then.
I can see you, I can see you, but you need to be in the screen, not your mother, grandmother, or whomever she is, okay?
Oh, okay, okay, yes, ma'am.
Who's on the Motorola?
Oh, my grandma.
No, I ain't on the motor.
No, I'm not,
Oh,
I'm talking
oh,
to someone else. I'm talking to someone else. Unmute your device to the person smoking with the Motorola.
It ain't not us.
It ain't none of us, you know that.
I'm muted. Jesus.
I'm on the iPhone.
I'm not talking to you, ma'am, but what is your name?
My name is Kelsey P.
Thank you. You're on here twice for some reason.
Because it
I'm
wasn't,
talking to the person on
it
the
wasn't letting me
Motorola.
pull up the video on my computer, so I had to get on my iPhone so I can pull up a video.
Okay,
So
I'm
I
gonna
can-
remove the device then. Okay, very
Okay.
good.
Thank you.
No problem. Maybe if you put whatever you're smoking down, you can see that you need to unmute. And ma'am, who I believe you're holding a child or a child's laying on you, what's your name?
Marissa Collins.
Okay, Collins is here, Gibbs is here, and Petener is here. Let's see. Then we have we have Gibbs. And then sir, on the Samsung, can you tell me your name? gonna remove the person who doesn't know how to unmute themselves.
Jonathan Johnson.
Your volume is really low. I couldn't hear you. Sir?
I'm sorry. Jonathan
Yes, hear me?
Johnson. Yes.
Jonathan Johnson. Very good. Okay. We're ready on.
We're ready to proceed on both Collins and Gibbs, Your Honor.
State of Michigan versus Marissa Collins, 26-01205 and 1206. Appearance, please.
So thank you, Your Honor. May it please the court, Assistant Prosecutor Smith, here on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Ms. Collins, who's apparently via Zoom.
Okay, Ms. Collins has a dog license vaccination ×2. How are we proceeding?
At this point, Ms. Collins has informed me that she has a rabies vaccination appointment set for a week from Thursday, so the 25th of June. At this time, we would just ask for more time for her to both get the vaccination and also get the license once the vaccination has been completed. We've asked for 3 or 4 weeks.
July 7th at 10:30. July 7th at 10:30. You have any questions for the court today, Ms. Collins?
No, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
You're all set, ma'am.
Thank you. Have a great day.
Same to you. So you were ready on who else?
Gibbs.
State of Michigan versus Jaquel Gibbs, 25-01092. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Mr. Gibbs, who's appearing via Zoom.
Mr. Gibbs has 2 counts of assault and battery. Was there an offer?
There's no offer at this time, Your Honor. I asked that this matter be set for a final pretrial, and we give the parties an opportunity to develop a resolution. No objections.
Final pretrial July 14th at 8 a.m. Jury trial August 26th at 8 a.m. Mr. Gibbs, you need to appear in person for every single one of your future court dates. You should never appear via Zoom again. Do you understand that? Unmute yourself, please.
Yes,
You
I understand,
that?
Your Honor.
Okay, it's
Yeah.
very disruptive. It's conversations going on in the background. Your grandmother or your mother is operating the device and not you. That's not the appropriate way to use Zoom court. And so you will appear in person for all. You will appear in person for all of your court dates. Your next court date is July 14th at 8 a.m. Your next court date after that will be August 25th at 8 a.m. in person. Do you understand that?
Yes, I do, Your Honor, and thank you very much.
No problem. Any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
You're all set. You're free to go, Mr. Gibbs.
I was the one that pressed unmute that time too, Your Honor.
It was not just one time, it was multiple times, actually. But you're all set for today.
Yes, ma'am.
Your Honor, can I speak to
I will.
She needs to speak to your attorney.
No, she has. Issue at this point? Did she issue at this point? No.
For whom?
Emily Bedell.
I did not call the case. Is she here?
No. She is not, I did not see her in the gallery or the hallway, and our office currently does not have any contact information listed for her either.
Well, it should be short, you know. Okay, and are you representing anyone else or are they on this trial?
I have Maurice Quayles, similar situation as to Bedell. It's
No contact.
no contact information listed with us, and they're not seen in the hallway or the gallery. And finally showed that had found it out.
Internal issue. So everybody is. No worries. Let's see, this is Ms. Bates. I don't know if he gave me their file back, did he? The record in the matter of the, wait, who represents Ms. Bates?
Judge, Attorney Strong.
Oh, okay.
I believe she's talking to.
She's talking to the person in
James Moore
custody.
Davis.
Mhm. And then Mr. Reader, does he represent himself? Yeah. We should do that.
Pardon, Reader?
Yeah, it's probably a motion set aside a conviction. You're on the record in the matter of the people of the state of Michigan versus Martin Reader. This is in file number 20-01496. Council might have your appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Okay, Mr. Reader is present via Zoom. Mr. Reader, you are without counsel for this purpose, correct?
That's correct.
Okay, this is the date scheduled for a motion to set aside a conviction. The court is in possession of your request. You're seeking to set aside MDOP less than 200 and assault and battery from date of conviction, July 23rd, 2020. The court does have a letter from the Office of the Attorney General. They have no objection to the setting aside of conviction if the court determines that it's consistent with the public welfare. Would the county prosecution be taking a position at this time?
We defer to the court, Your Honor.
Sir, please advise the court what you've been doing since 2020 when this conviction was sustained.
Well, all the conviction stuff was surrounding a divorce. Since the divorce, moved forward in my career, promoted a couple of times into supervisory positions, operating a small business, and then the divorce. My co-parent, we've developed a good co-parenting relationship, and things are going well there too. Aside from that, I've been just raising my children. I just got married in February, so now I have a stepson as well. And I built a house also.
So you've been busy
Very busy.
and productive. The court does have or have received letters of reference in support of you, one from Delta Township, and then one from a Luke McAllister, and then an Angela Reader, and then lastly, I believe, Anthony Warner. So all very positive letters of support from your community. I want to applaud you for regaining control over your situation. I don't think had any other convictions ever other than this situation. So you're a classic candidate to have this set aside. I find it to be consistent with the public welfare. I'll grant your request today.
Thank you.
Thank you. You're all set. Thank you.
Thank you.
No problem.
Is there, since I'm without counsel, is there anything further that I need to do on my end?
There's nothing you need to do on your end. I signed the order. It'll be sent to the state police so that they can retract what needs to be retracted.
All right. Thank you very much.
You're welcome. Best wishes to you, sir.
Bye.
Okay, this is the matter of the state of Michigan versus Tammy Bates, 26-00375. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Tammy Bates, who is standing to my right.
Okay, Ms. Bates was scheduled today for a bond violation. And the court had already indicated to the your counsel, that we would hold the bond violation until after we've gotten a competency evaluation report, which I think is pending. I think they've done the evaluation and we're just waiting for them to send the report. However, and I wasn't going to address bond due to the pending violation until I learned that there was someone here in support of you. Is that your mother?
Yes, ma'am.
Okay. And so she's very concerned about your well-being, and that shows the court that there is someone that's at least going to look out for you, make sure you don't miss your court dates to the extent that they can. You wanted to address bond.
Yes, Your Honor. It is my understanding that Eaton County has issued a bond for Ms. Bates. So based on what you just said, the support of her mother, we would just ask this court today to consider releasing her as well on a bond. Even if the court thinks that it's appropriate to have a tether, we would absolutely be amenable to that as well. We leave it to the court's discretion.
I'll issue a PR bond with GPS tether. So you're going to reside with your mom, or where are you going to reside?
1338 Eureka.
Okay, that's the same address you've been residing at.
Yes, ma'am.
Has your telephone number changed?
Well, my phone has been off since I've been in jail, so I do not have that information, but my mother's number is a very good number to call.
What's your mom's?
517-243-0437. And I will make sure that I come to every court date.
We don't remember phone numbers anymore, you know that, but we always remember our moms, at least we should.
Always.
Have to.
She remembers.
It's been that way for years and years and years, so I think that's why too.
You should remember that. I was recently talking to someone and they were like, if something happens, I don't remember anybody's phone numbers. You remember someone, your emergency contact.
Always remember my mom. She's
That-
my support.
Agreed. And you know how you can support her back?
How, ma'am?
By not making her have to come to court for you.
Absolutely. I'm going to put myself in outpatient rehab, and I'm also going to try to get into Rise for Sober Living.
That's good. Rise Recovery, probably a really good place for you to be. Hopefully, your attorney can help you navigate getting connected to that program.
Thank you, ma'am.
Okay, so we will, I think this matter is scheduled for a review July 14th. That review only is going to go forward to the extent that we actually have received a report. If we receive a report before then, once we receive a report, I have to hold a hearing within 5 business days. So you'll be notified. So that's why we have to have valid contact.
Okay.
So that whenever we get the report from the forensic, it's going to be set immediately for a court hearing. Your attorney is going to try to make contact with you or your mom if your phone's not on to let you know. You do not need to appear in person for that. So if you have a video on your camera, you can appear virtually, okay? Just be in a quiet place that's appropriate for court, okay?
Yes, ma'am.
Otherwise, if you don't have the ability to appear via Zoom in a quiet place, just come in person, okay?
No, ma'am.
Okay, do you have any questions?
Oh, my mother would like you to send a mail to her house.
What's that address?
7930 South Lowell Road.
South
Lowell Road, St. John's, Michigan.
48879.
Spell your street name. Spell it, the street name.
Lowell.
Lowell, okay, very good.
South Lowell.
South Lowell, I have that. I just didn't know
Okay.
if she was saying low or Lowell, okay. Very good, so we will have mail sent there, and then we have your number, but Ms. Straub also has your mother's number if she needs to call you for that next hearing.
Yes, ma'am.
So that you can appear immediately for that, okay?
Yes, ma'am.
All your other bond conditions will continue, including the no contact order,
No problem.
especially including that, okay?
Yes, ma'am.
No contact directly or indirectly. You can't be within 2,000 feet of where that location is. And because you're gonna have a tether, it's going to alert you
Yes,
and us if you are within that jurisdiction, okay?
Promise.
Okay, very good. She absolutely can come to your house. Absolutely. Is she going to stay at your house or you may just visit?
Visit. I have a curfew and everything with the tether, correct?
I have not given you a curfew at this time.
Okay. I can go to my mom's house.
You absolutely can go to your mom's house. Any additional?
Thank you.
You're welcome.
Thank
Any
you so
additional
much.
matters for the record?
Nothing from the people, Your Honor.
Thank you.
Thank you. You'll be released once they can get you the tether, okay?
Thank you, ma'am.
That's gonna be in Mason, okay?
What about Eaton County?
Oh, that's right. You're in Eaton County. You
Yes,
gotta,
ma'am.
they'll release you now. They were holding you because there was no bond here.
Okay,
But it sounds like she has a bond in Eaton County.
yes, I do.
Okay, so
We're
once you,
prepared to pay it.
I don't know what that bond is. That's up for you all to take care of. You don't have to pay a bond for this one. You just gotta get a tether.
Okay, yes,
And
ma'am.
I'm sure, I believe you're eligible for the indigency status so that the payment will be covered for your tether.
Oh, thank you, ma'am.
You're all set.
Mm-mm, sorry.
Not at this time.
You can later, mom. I'll get up today. I love you. Thank you, ma'am.
You're welcome. Let's see, they put Davis on, is Rhodes downstairs? Joshua Rhodes?
Yeah, Kent County, right?
Yep, I think that's the last one for the morning.
Did we do,
Unless I missed something.
did we do Bermudez?
We did not do Bermudez. Is that a sentencing?
Yes.
Oh, we didn't do me either.
Or me.
P Turner.
You think I don't know? That's what you all get for staying into the judicial business. I am handling jail. I did not ask any of you all to unmute and tell me that I didn't do you. I know I didn't do you. You're sitting on Zoom waiting for your case to be called. Your attorney can only handle one case at a time. You can bring up Rhodes. We'll do the 17th last.
Gotcha.
Okay, and then Davis is on. What are we doing with Davis?
Your Honor, it is my understanding that Mr. Davis would like to plead on all
All the files?
of.
I only have one file.
He
Got
has
another one.
On my docket today?
Not today. Remember, Your
the
Honor.
contempt and the pretrial
Oh, okay.
matters, Your Honor.
Oh, you can recall, he had another matter which I wrote a motion on, which he got another case with that same victim, another victim. He has
Oh,
like- he has
yeah,
like 4 or
yeah.
5.
Got it. Well, we're only gonna address this one today. So we gotta possibly do Judge Buchanan stuff. So I've been told, he's having a trial. He's gonna plead to the charge and the bond violation, you're saying?
That is correct, Your Honor.
Oh, there's more than one bond violation on here. 1, 2, there's 3 bond violations.
Well, one-
Actually, 1, I don't know that he's been arraigned on yet. Phone calls from the jail. I know you lying. I know you lying. I know you lying. I know, there's no way come on. Not within 2,000 feet is the first violation. The second one. Again, within 2,000 feet, and then now, and while in jail, pending 2 violations. Phone calls. To Jasmine Gilpin.
She's here.
What are we doing? All 3 violations?
We'll see, Your Honor.
Oh, okay. Is that correct, sir?
Yes.
You need to come closer to the camera so we can see you, because we can't, you're so far away. You can stand up. Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay. You have the right in the domestic violence to maintain your innocence and proceed to jury trial and require that the prosecution prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt You have the right to see, hear, and question under the confrontation clause of the Constitution any witness called to testify against you. You have the right to subpoena witnesses that will testify on your behalf. You have the right to remain silent at trial, and they can't use the silence against you. You would have to give up all of those rights if you would like to plead guilty to domestic violence. Do you understand that?
Yes, ma'am.
Okay, and then as to the 3 violations that we have here of your bond violations are contempt of court order. Each of those are punishable with a maximum penalty each of 93 days in jail. Do you understand that?
Yes, ma'am.
You have the right to have contested hearings on each of those violations and the right to have evidence brought forth to establish beyond a reasonable doubt if you in fact violated your bond conditions. Do you understand your right to have hearings on those bond violations?
Yes, ma'am.
And are you willing to waive your rights and plead guilty to all 3 violations that are pending against you?
Yes, ma'am.
Is anyone threatening you to get you to waive your rights and plead guilty today?
No, ma'am.
Any promises being made to get you to waive your rights and plead guilty?
Yes, ma'am.
What's the promise?
Oh, no, ma'am. Sorry.
Okay, and you're not on probation or parole at this time, correct?
Correct.
Okay, you understand that by pleading guilty, it could result in the conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Yes.
It also, the charge as well as the bond violations could result in possible jail time. Do you understand that?
Yes, ma'am.
And then the underlying conviction could also result in a charge or conviction that may prohibit you from visiting or getting immigration status in certain countries. Do you also understand that?
Yes, ma'am.
As to domestic violence, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes, ma'am.
As to the bond violation that allegedly occurred on April 30th, 2026, how do you plead?
Guilty.
As to the violation that occurred on May 17th, 2026, how do you plead?
Guilty.
And as to the violations of contact from the jail recorded phone calls on May 17th through May 27th, 2026, how do you plead?
Your Honor, I do believe Judge Buchanan already handled that matter.
Handle what matter?
The jail calls on violation.
She can't handle a bond violation. It's a violation of this case.
Okay. I do believe she gave him 36 days.
No, she did not. She did not address it. It could have been a bond violation on another case he has, but not on this one. It's a violation of this case, and she can't handle my bond violation, nor did she, because there's no note. He hadn't even been arraigned on it. They put this in my file on June 3rd.
Yeah, several cases.
Yeah.
She probably addressed the bond violation. I believe there was a stalking matter before her, and there was a.
So it's separate violation, has nothing to do with this.
Okay, understood.
And as to that violation, how do you plead?
Guilty.
Factual basis on all. Have a seat.
Okay, my turn. Mr. Davis, on or about April 30th of 2026, were you located at 3232 North Waverly Road in Lansing, Michigan?
Yes, ma'am.
And is that located within Ingham County?
Yes, ma'am.
And were you at that location with a Jasmine Joe Gilpin?
Yes, ma'am.
And did you have a dating relationship either at that time or previously with Ms. Gilpin?
Yes, ma'am.
And did you assault Ms. Gilpin? Did you bite her?
Yes, ma'am.
Are you satisfied?
Wasn't in self-defense.
Was it in self-defense?
Yes, ma'am. I mean, no, ma'am.
It was his, oh, okay.
We're good for that.
Okay. Relative to the alleged violations ranging between May 17th and May 27th of 2026, did you have contact with Ms. Gilpin via telephone from the Ingham County Jail?
Yes, ma'am.
Did you know you weren't supposed to call her?
Yes, I mean, yes, sir. I didn't, well, I didn't, I wasn't really thinking about a lot of stuff. So I just,
Question, it's really simple, and I'll ask it
yes,
again. You called her and you knew you weren't supposed to call her, yes or no?
correct.
All right, thanks. We're good for that.
Okay. On May 17th, around 11:59 p.m., did you have contact with the Jasmine Joe Gilpin?
You said on May 17th?
Yes, of 2026.
Correct.
Okay, and were you under, did you have a bond at that time?
Yes, but I had to hold as well.
Okay, and did your bond conditions instruct you not to have contact with Miss Jasmine Joe Gilpin?
Yes,
Okay, and you did anyway?
yes.
On April 30th of 2026, around 5:23 p.m., did you have contact with Jasmine Joe Gilpin?
Yes, ma'am.
Okay, and were you on bond at that time?
Yes, ma'am.
And did you have a bond condition that instructed you not to have any interaction or contact with Ms. Jasmine Joe Gilpin?
Correct.
But you had that contact anyway?
Yes.
If we're satisfied with the factual basis, I'll accept your plea to the violations and to the underlying charge and find your plea to be freely, voluntarily, and intelligently made. Have a sentencing date, please.
August 4th.
Sentencing is going to be August 4th. He's being held on what besides this?
I do believe he is being held for contempt for a violation stemming from jail calls happening between May 17th and May 27th.
Before Judge Buchanan.
Yes, Your Honor.
Okay. Same victim.
Yes, Your Honor.
He has another case.
Yes, he has another case with a separate complaining witness that I think that jury's trial is scheduled for July.
Okay. All right. Well, we'll know that he's in custody and that the probation department can meet with him while he's in custody to prepare pre-sentence recommendation. Any additional matters for the record?
No matter for the record, Your Honor. Or was the court be moving the sentence on the
August 4th. I'll do all of it on August 4th.
Okay, is he gonna be held in custody until August 4th?
Correct.
Okay. No, well, nothing further.
Nothing further.
Let me remind you, in case you forgot or in case you believe that there are certain reasons in where you could think about giving Miss Jasmine Gilpin a call. You're not allowed to call her. You're not allowed to have anybody else call her. You're not allowed to use another inmate's number to call her. You're not allowed to call another family member to ask them to send a message to her. Do you understand that?
Yes, ma'am.
Okay, so you relieve any thoughts of that from your mind and focus on something else more productive while you're in timeout, okay?
Yes, ma'am.
all of the bond conditions of no contact order will continue. You're all set. You're all set. So you can let the deputy know you're done.
Appreciate it.
You're welcome. Who's representing Jonathan Johnson? Oh, who's that she has over there? That Rhodes? That's Mr. Rhodes. Whoever's on the Motorola needs to start their video. You have to unmute your device. What's your name?
Maurice Qualls.
That's my client.
Mr. Claus, why are you late?
Huh?
Why are you late?
Why am I late? Because I've had court today.
No, why are you late? You were supposed to be here at 10:30.
I've been here. I've been sitting here for over.
No, you're not. No, you're not.
Yes, I have. Yes, I have. I started at 10:19. I have been here.
You were the one smoking?
No, it wasn't no smoke.
Oh, everybody saw it, but you didn't see it.
No. Yeah, I've been here since 10:19.
You were smoking. Someone
A
want no
cigarette?
smoke. I didn't ask you what you were smoking. You were smoking something, and that's why I booted you. And that's why I booted you. You don't have his contact information?
No, there's nothing there. I got
What's your phone number?
Case number.
Because I issued a bench warrant for you because your attorney had not spoken with you, and you were not here when we.
I have not talked to. Yeah,
You
I
were
have
not
been here
present.
since
You were not
10:19.
present when I called your case.
Yes, I was.
Well, then,
Ma'am,
if you were here
ma'am,
when we
I
called your
have been
case,
here
why do
since
you say I'm right here?
I've been here since 10:19. Nobody said my name.
Yes, I did.
I believe he was unable to unmute his phone.
He didn't hear us call his name. He just said nobody called his name. We called his name. Where are you now, sir? Where are you now?
Astro 113 at my mom's house.
What's your phone number?
I don't know my phone number.
Well, you better find out.
Oh, all this. I gave y'all my phone number. Let me look it up.
Oh, your attorney doesn't have your phone number.
Let me see. Let me go to my phone.
And you didn't give us your phone number. You told the magistrate, then you didn't remember your phone number. She wrote it down in the file.
I'm sorry.
Grown man. You told the magistrate you didn't know your number. Too grown to not know your number.
I don't call myself.
I don't care if you call you sound, you know how special you sound saying that? You're supposed to know your phone number and your address.
I don't even try to give people my phone number, man.
Well, who cares? You're supposed to know your phone number. I think it might be high, to be honest with you.
I don't even smoke weed. You can give me a drug test right now. You want to?
Okay, come in. You can. Okay, perfect. You can come in person, so we can do that. Let me know when you get here.
Okay.
Thank you. Who's representing Jonathan Johnson?
I am, Your Honor.
Okay, you ready on him?
I am.
State of Michigan versus Jonathan Johnson, 26-01163. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Jonathan Johnson, who is appearing via Zoom.
Okay, this is a pretrial for stolen property. How are we proceeding?
We ask this matter be set for a final pretrial.
No objection.
No offer,
No,
correct?
no offer.
Final pretrial July 14th at 8 a.m. Jury trial August 25th.
Okay. Okay, Mr. Johnson, you need to appear in person July 5th, 14th?
Yeah.
July 14th at 8 a.m. And then your jury trial is gonna be August 25th, also in person at 8 a.m., okay?
Is there any, is there any possible way I can do Zoom? My girlfriend is about to have surgery Thursday and she has a herniated disc. So she's gonna be down for 4 to 6 weeks. Is there any way I can do Zoom? I also live like an hour away from Lansing.
No, you have to appear in person.
Okay,
We don't do Zoom trials.
okay.
Okay, so that's just the way it is. And the only other thing is for you to resolve it, and then you don't have to appear. But if you want to move forward with the trial has to be held in person.
Well, that actually wasn't what my attorney said, so now I'm a little confused. She told me she was gonna try to get it adjourned. So, because I haven't even met with her face to face yet.
Okay, so.
I'm at work. I'm at work right now.
Mr. Johnson.
Yes,
Mr.
ma'am.
Johnson, we got you a new court date, sir, okay? Your new court date is July 14th. That's the date that you have to appear in person.
Okay.
So we got
That is an
exactly what
adjournment. That's an adjournment.
yeah, we got
Okay.
what we asked, okay?
All right. I apologize. Sorry.
Okay.
Okay, you're all set, sir. Thank you.
All right. Thank you.
State of Michigan versus Renee Zellick, 12-044045. She's just been sitting there very patiently.
Okay.
Come on up.
Okay.
Okay, this is your special day. You are requesting a set aside of a conviction from 2012 for a child abuse fourth degree. Do I have a letter from the AG's office? Let's see here. I do have a letter from the Office of the Attorney General. Maybe I don't. Let's see here. Okay, maybe the Attorney General is a little behind because they did not send a response, but we're gonna move on without their response because they've had sufficient time to do so. Does the county prosecutor have an opinion or position at this time?
Your Honor, I just received this motion or notice of this motion today. I would just say that the nature of the charges are concerning. I understand that they are about 14 years old. But in any case, we would defer to the court on whether or not it determines to grant the motion.
You said the nature of the charge, meaning just
child
the fact that it was child abuse fourth or like specific detail?
No, just child.
Oh, okay, sounds good, okay.
I believe.
Child abuse fourth could have been, she had a naughty child and she spanked her legs. Not that concerning.
But I
I've rehabilitated myself since then. I've been in and out of therapy. I graduated with my associate's degree in human and health services on September 14th of this past year. Out of Clearwater, Florida, Ultimate Medical Academy. I've never had a difficult time finding a job until I finished my associate's degree with this conviction for some reason.
I can imagine that you could have some concerns or issues getting.
I mean, I can understand why. I mean, I wasn't in the right state of mind. My daughters were really young at the time. I was a single mom, commuting my girls back and forth to East Lansing schools and raising my daughters on my own. And they were just, I had us in counseling through East Lansing, MSU. I was trying to do anything I can to like raise them. And it was just like I was not in my right state of mind at the time, and they
You
were
were overwhelmed, it sounds like.
yeah,
How
and they
many
were
children do you have?
I have a son now who's 12. But at the time, my oldest daughter, Savannah, was 5, and Sierra, not at that time, but at that time, they were like 5 years apart.
Okay, so it was 2 daughters at the time?
Yeah.
Okay.
And they were very argumentative, and I told them, I'm like, if you're gonna argue with me when I'm driving home, because I'm commuting you guys back and forth to school and track and field, your sports, and work and this and that, if you're gonna argue with me, you can just get out of the car and walk home, because we are not that far for them to walk home. And they just kept arguing. It was really bad. And I didn't mean to.
Is that what happened? They walked home? Or
No,
what?
I slipped. I ended up back slipping my youngest daughter in the face on the side because she was on the passenger side, and I ended up back slipping her in the face and made her nose bleed.
And so since then you've done counseling?
Yeah.
Okay, is it they would be an adult now. Did you do counseling with the child at the time?
Yeah, I did.
Okay, was CPS involved?
They just ended, yeah, but they took my daughters away. They didn't have me go through counseling or nothing.
Oh, they took the children from out the home?
Yeah.
Okay, did you ever regain custody of them?
After about a year.
Okay, but didn't have you do counseling?
No.
So you did counseling on your own?
Yes.
Okay, and then since then, you have been in a little bit of trouble since then as well?
Yeah.
Okay, when did you do this counseling?
I did that counseling, I'm trying to remember, like 2000 well, after that, I met a guy, my son's dad, and I moved him in, and just a lot of bad stuff happened. And I went down a rabbit hole with him and his acquaintances, and I got pregnant, and my daughters, they were already gone. So after when I was pregnant with my son, and after I had him, I went through years of counseling to get help.
Okay. Well, you had something happen in 2022 though? Was that with the father of the?
Yeah.
Okay. Have you gone through counseling since then?
Yes, I'm still in therapy at Waverly Wellness, UCMH.
Okay. Okay, that was originally, the 2012 conviction was originally a child abuse third, and we pled to it with amended child abuse 4. And you said you were just notified, or your office was just notified this today?
I wouldn't say my office.
Oh,
I would
okay.
just say me in general about the file, since I was no longer assigned to this court. But again, I think, it's.
Oh, okay, that's why, I'm looking at the proof of service. I don't know why they sent this for this. The proof of service says that AG was just served on June 10th. I have to reset this. They haven't had sufficient time to respond. They have to have time to get it. I don't even know if they received the mail. Get the mail and submit a response.
I just had one of my case managers from Waverly Wellness help with me with it last week.
Okay.
Because when I got everything in the mail, my car was down at the time and I didn't have the money to take a bus or no backup. So I had to wait for my car to get repaired from DHS.
Okay, so I have this reset because if you serve both the prosecutor and the AG on the 10th, so that was 6 calendar days away, not even a full business week.
Yeah.
So that didn't give him sufficient opportunity to review, and the AG's office has the right to submit an objection, or if that is something that they were intending to do. I've never received an objection, but they have always responded. So I am going to go ahead and give this back to Mr. Farnham, our operations manager, so that he can follow up with the AG, and then you'll get a new date for this, okay?
All righty.
All right, best wishes to you for today, okay?
Thank you.
You're welcome. And then we have Kelsey P. Tanner, who's representing her.
I am
She Straub. This is the state of Michigan versus Kelsey P. Tanner, 26-01337. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justin Straub on behalf of Ms. P. Tanner, who is here via Zoom.
Ms. P. Tanner has a attempted police officer assault pre-trial. Was there an offer?
I think if it's an attempt, that was probably the offer, but there's no additional offers at this time.
It's not the offer, that's the charge.
Attempted police officer?
That's the original charge.
Oh, okay.
It was originally charged that way.
So who knows? But there's no offers at this time. We ask that this matter be set for a final pretrial to continue negotiations with the defense counsel.
No objection.
July 14th at 8 a.m.
Why do we need a final control? I'm confused. I don't require officers to appear, so. We can just go
Well,
trial.
it's my understanding that we're gonna work towards the negotiation.
Oh, well, then we just need a pre-trial. I mean, we don't need to have a final one. Pre-trial, the final pre-trial means it's gonna be at 8 a.m.
You can do another pre-trial. That'll be perfect. Thank you.
July 7th at 10.
July 7th at 10. Yeah, because if it's final pre-trial, we only have limited slots for those. So, Ms. P. Tanner, you can appear via Zoom again, July 7th at 10, and your attorney's going to try to continue to negotiate on your behalf, okay?
Okay.
Have any questions at this time?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Not from defense. Thank you, Your Honor.
Okay, you're all set. Thank you.
Thank you.
You're welcome. This is Mr. Joshua Rhodes.
Yes.
State of Michigan versus Joshua Rhodes in file number 24-02722. Appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justin Straub on behalf of Mr. Rhodes, who is standing to my right.
Okay, Mr. Rhodes is here for retail fraud third. How we proceed?
Further defense counsel.
Well, we were made an offer, Your Honor, for trespassing with agreement to pay restitution in the amount of $22.39. It is my understanding that Mr. Rhodes will be accepting that offer today.
$22.39. We just need the restitution form.
Both the types of rights and restitution form, Your Honor.
Thank you. Quality area. Okay. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You put your hand down. Is this your signature, sir, on the divisive rights?
Yes, ma'am.
You've gone over these rights with your attorney, correct?
Yes, ma'am.
You understand that you have the right to proceed to trial
Yes, ma'am.
and the right to maintain your innocence and require that the prosecutor prove your guilt beyond a reasonable doubt?
Yes, ma'am.
the right to remain silent and not have it be used against you, the right to question or cross-examine any witness called to testify against you, and the right to take the stand and give your own testimony. You understand that? You're willing to waive each of those rights and plead guilty to trespass? Anyone threatening you to do that?
No.
Any promises to get you to waive your rights and plead guilty?
No.
Are you on probation or on parole?
Not this time.
Okay, but you have another matter pending in another county?
I believe I got 16 months probation coming up. I haven't got to it yet.
Okay, you haven't been sentenced yet.
I've been sentenced. I'm actually going to be released in 5 days. Released on 23rd.
Oh, okay. To do probation?
Yeah,
Oh.
16 months probation.
Okay.
And also, is there anything else that we need to, that I have to come back for? Or I think this is it?
Do you have any other files here is what you're asking me?
Yeah.
You don't see anything pending? Huh? Sorry. Yeah, this is the only thing we see for you. Okay. As to the retail fraud third degree, I'm sorry, that's been amended to trespass. How do you plead? Factual basis.
Mr. Rose, on May 20th of 2024, were you located at 500 East Saginaw Street?
More than likely, yes.
You don't remember?
Not really, but yes, yes, I probably was.
Okay, well, if I told you that location was Quality Dairy.
Yes,
Okay.
yes,
And were you asked to leave from the Quality Dairy?
yes,
Okay, and did you fail to do that?
yes, several times. We're satisfied.
For the satisfied with the factual basis, I'll accept your plea. Finding your plea to be freely, voluntarily, and intelligently made. He's been in custody since April. Credit time served and restitution of $22.39 must be paid within 30 days. You understand that?
30 days.
30 days. Yeah.
I have an issue with that, you know.
Why, you want to pay it sooner?
No, I don't have my ID or my social security card, and I'm gonna be placed into a alternative direction program there in Grand Rapids. It's gonna take me, I don't know. how
Thought you were
long
going
it's
on probation, so you're going into a program.
I'm going to do a program and I'm being placed on probation.
Okay, and how long are you gonna be in this program?
6 months. But I'm allowed to work in this program. My problem is I don't have any identification to get a job right away.
So how much time do you think?
How are you gonna get your identification?
I'll give you guys a call. I got it.
Will you?
Yes, I will.
You have a phone number? What's your phone number?
I don't have a phone.
No phone.
I have an email address.
Okay, what's that?
Joshua Rhodes, all lowercase, 517 gmail.com.
At Gmail, you said?
Oh, yes, ma'am.
Okay. Well, you're gonna have to remember to come back here, because what happens is restitution, unlike fines and costs, I can't wait. Restitution, this file will stay open until infinity.
And $22.
For $22.39.
Not that much.
You could get picked up on a warrant for $22
Yes, yeah.
because you never paid it. You see what I'm saying? So you
I
gotta
just come in
remember,
and pay $10, you know, make a payment.
you can come and pay $1 for all I care. You gotta be paying on it. So
Yes, ma'am. Yes,
okay?
ma'am. Okay, I can do that. Yes, sure.
Okay.
Is this the number right here to contact the court? 483-4445?
Sounds like it.
Okay.
Yeah, it sounds like the clerk's office. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing, thank you.
Okay, you're all
Thank
set.
you.
Thank you.
Have a great day.
You too.
David.
The last person we have down there?
Yeah, it is.
Okay, and then I'm assuming they found someone else to finish your docket.
Kelly said that they're
Oh.
okay. They only have
Yeah.
50 things, so.
They're fine. Start me in the hallway with Dave. Like, do you have much on here? I was like, if y'all need help, just send it down. But then he was in there, he felt chilling. They was mostly excited.
Wait.
This 2026. Yeah, that's because he failed to appear. So when that happens, we have to get a new one, and there was not one requested. On the record in the matter of the state of Michigan versus David Bermudez Jr. 20-02772 appearance.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. David Bermudez, who is standing to my right.
Mr. Bermudez, long time no see. Where have you been?
My mother passed away a while back, so I've been mourning her death, so I haven't.
When was a while back? 2024?
Yeah.
Okay, and so what does that have to do with you coming to court? I don't even have an updated report. You pled guilty to a domestic violence second. It was originally charged as a DV third and an assault with intent to great bodily harm. So this was pled down. I don't really have a choice in this matter, but you can make allocation.
Your Honor, I heard from Mr. Bermudez that he is pursuing mental health support through CMH. He's been interacting with CMH even while he's been in custody. He has also made a representation that he will soon be released into rehab, specifically into TRICAP, upon the completion or resolution of this matter, as well as I think he has a civil warrant. Maybe he thinks he has a civil matter that to that degree, Your Honor, we don't object to the recommendation for the pre-sentence investigation. We do recognize that it is outdated at this point.
It was the same thing we would have got to anyways. They didn't think he was a good candidate for probation then, and he said, I'll show you. I'm not even gonna come back to court. And so he definitely is not a good candidate for anything other than jail time. So that's what we're going to do. And you said he is obviously pending something else right now, correct?
That I'm not sure.
Civil warrant from the back view.
Oh, so war, that's not real. Okay, let's.
That's not me.
Got it. Well, looks like he was arraigned on this in April. I the magistrate. 93 days in jail. He'll get credit for, he had 22 days back in 2024, plus at this point, he probably has another 60 days. So 90 days Ingham County Jail will credit him time served. And he'll. I think there was no restitution. There wasn't, and then he'll be all set. Any additional matters for the record?
Nothing from the people, Your Honor.
Not from defense, Your Honor. Thank you.
You're all set, sir. Thank you.
Yeah, well, to this.
All right.